Good morning. This is the Workplace Violence Prevention webinar here at ConMaCL Cary. This is the first Cal OSHA webinar in our new webinar series. So we're very excited to have everyone here today. My name is Rachel Kahn, and I am the chair of the California practice. And I am very excited to be here today with my colleagues, Megan Shaked and Andrea Chavez. Just a quick note about me. I am a partner here in our San Francisco office, and I have recently joined CMC in July from Nixon Peabody, where I chaired our national OSHA practice. So again, I'm very excited to be here and focusing here in California. And I'm also here with my partner, Megan Shaked, who focuses on Cal OSHA and employment law as well. And she is also here in our California office. And we've recently been joined by Andrea Chavez, who is a senior counsel here in California, but down in our LA office. And Andrea was with me at Nixon Peabody, and she is now agreed to come over and join us here. And she does all things Cal OSHA, labor law, California employment. So her and Megan are full utility players. And so we're excited to have Andrea here as part of our team as well. So the agenda for today, again, we have a lot of stuff to cover. We're going to start off by just doing some context about the pre-SB 553 world. For those of you that have been dealing with workplace violence issues previously, you are probably familiar with what regulations, what standards, what tools are available to employers in this pre-SB 553 world. Megan's also going to talk a little bit about the background of SB 553. For those of you that had been following it in the news, been following it through the legislature, been following the Cal OSHA regulation, you'll know that it had quite a history, and it was definitely a roller coaster ride of a bill. There was a lot of amendments. There was a lot. It started off as healthcare, and it got closer to the Cal OSHA draft by the end of it. So she'll take us through all of that background. Then I will get into the real nitty gritty about what the final bill looks like and what to expect in terms of compliance and pitfalls. And as somebody who's worked a lot in workplace violence already, who has worked a lot with the Cal OSHA healthcare workplace violence standard, I can tell you some of the pitfalls that I already see in this bill from the start. We'll also talk about the status of the Cal OSHA regulation. That is still out there. That is still in rulemaking. So we are not done with workplace violence yet. And then Andrea is going to be talking about the implications for employers. And that's particularly within other intersections of laws. So like any law, SB 553 does not sit in a silo. It interacts with many laws, including employment laws, that you have to be really careful of. And so we want to make sure that we flag those for you today so you're aware of. But one major theme, and you'll see this as we go through and talk about the complexity of this law and the complexity of how it interacts with many laws, is that, to be compliant, to have a program that really takes into account the full legal landscape. This isn't just an EH&S problem. This isn't just a security problem or HR or legal. You really need a comprehensive team to be able to navigate this. And when we flag some of the pitfalls, I hope that you'll see that you really need all of those perspectives. And with that, I'm going to turn it over to my partner, Megan, to start us off on some of the background, or pre-SB 553 background.
Thanks, Rachel. Hi, everyone. Thanks so much for joining us today. Like Rachel said, we're going to kind of set the stage a little bit to understand how we got here and where we go from here. So workplace violence as kind of a hazard in the workplace is unfortunately not something that's new. The Department of Industrial Relations in California, which is the umbrella agency under which Cal OSHA falls, it has recognized workplace violence as a hazard in the workplace, or it can be a hazard in the workplace, and it can include, threats and actual acts of physical violence at work, and that this is, a serious concern for the agency, and they have addressed it in a number of ways, even prior to the regulation that Rachel mentioned is still in rulemaking, and even prior to the origin of Senate Bill 553. So what has existed in this landscape already is an existing workplace prevention standard for healthcare. Healthcare was identified as an industry that had higher rates of workplace violence incidents. And so we have in existence regulation under 3342. This is an incredibly complex and robust regulation that requires a lot of healthcare employers who fall under it. And Rachel in particular has quite a bit of experience dealing with citations that have fallen under this regulation, as well as compliance programs, working with employers to make sure that they comply with this program. And it's been interesting to see how this existing regulation has kind of played into the framework of SB 553. The other existing regulation that the agency will often turn to if you have an employer or work site that's not within the healthcare standard, the California Injury and Illness Prevention Plan standard under 3203 is one that the agency will reference and will rely on in issuing citations, because under that regulation, employers are required to identify, correct, and train on hazards in the workplace. So if workplace violence has been identified as a hazard in a given location's workplace, then there's an expectation by the agency then that will be handled in the way that any other workplace hazard is supposed to be handled under the IIPP requirement. And so we saw the agency using 3203 and issuing citations after, for example, the Half Moon Bay shooting, which was a workplace violence incident. They relied on 3203. That, it remains to be seen moving forward. You would imagine that they would rely on the new regulation, but that is what they've relied on in the past. There's also quite a bit of kind of information and resources that employers have at their fingertips, things like industry standards and existing guidance under Cal OSHA, which has issued guidance for workplace security, which it's relied on for years and years and years to kind of give employers a framework for thinking through the hazard of workplace violence and what they should do about it. And so that's something that's available on DIR's website currently. It's a little bit skewed towards the retail industry. There's a lot of specific information that they put in there for employers in that context to kind of think through. And it, kind of remains to be seen what Cal OSHA will do with that guidance once SB 553 officially goes into effect. And then the last piece that's been in the works is a draft standard rulemaking for workplace violence prevention in general industry. And this came out of a petition that was filed with the Standards Board back in 2014. And it stemmed from workplace violence prevention and education. OSHA has started working on a standard. It went through its normal rulemaking process of having advisory committee meetings, and it did release an additional draft. But you can see 2014, they've released a draft in 2022. There is not a final regulation that has been sent to the standards board for a vote. So the rulemaking process for workplace violence is taking a long time, as OSHA rulemaking often does. And folks from the agency have admitted that a workplace violence prevention standard for general industry, so one that applies generally speaking across the board to most employers in California, presents challenges. It's challenging to come up with a rule that would apply to all employers. It's challenging to have specifics, tell employers exactly what they have to do, addressing the standard and kind of weighing all of the factors that go into play with having a workable rule. So in the meantime, with that context, we had some pressure from the legislature to kind of move things along a little bit faster. So we'll get more to that story in a minute, how we got to 553. But in the meantime, we did want to point out just a handful of additional tools that exist for employers, which are in the topic of restraining orders in California. So California has a number of different types of restraining orders that can be issued. Some of these are handled through the criminal system. Some of these are more civil in nature. For example, a civil harassment restraining order can be requested by just an individual to get a restraining order to protect them against another individual. But there is one particular type, which is called a workplace violence restraining order, that allows an employer to obtain a workplace violence restraining order to protect its employees. And so this is a very particular tool that can be, considered for use. It allows the courts to protect an employee in a number of ways, protect against, harassment, protect against somebody going to their place of work or going to their home. It can even cover family members. It can address the use of the restricted party's use of a firearm, access to a firearm, and it's, an official petition you file with Superior Court, go through a court proceeding, present evidence to the judge. The judge can issue both temporary restraining orders and a more permanent version of the restraining order through this mechanism. And what they're looking at in terms of the standard is whether an employee has suffered unlawful violence or a credible threat of violence in the workplace. And when there's no legitimate purpose for that. So they're looking at things like, actual actions taken against an employee or credible threat of violence, something that rises to the level of a reasonable person fearing for their safety. And, things that we sometimes see as facts to support getting a restraining order are things like, stalking somebody, making harassing phone calls, sending many messages over a short period of time. And, of course, any incident of actual violence, the courts will take that into consideration as well. Now, the restraining orders, as you can imagine, there's some pros and cons in considering whether to request a restraining order. And there's some limits as well. So the process, it can be involved. You want to move on acts of violence and threats of violence rather quickly. So you have a good argument for the judge that there's a need for this immediately, and that this will not, can't be resolved another way. But there's also, sometimes some barriers. You have to go through the court process. You have to, be presenting evidence. You have to serve, there's a formal service requirement. And of course, if you have the order, then there's the issue of enforcement. So if somebody violates the order, then additional steps may need to be taken to make sure that the protected employee remains protected.
And one thing I would just note, Megan and I both have a lot of experience in workplace violence restraining orders, and it's a great tool for employers to use. And as Megan mentioned, there's a lot of pitfalls to them. And I really encourage that if you plan on, if you're thinking about getting one for your workplace, to really talk through it with counsel, because, things like, who's going to be the declarant, can you properly serve this person, are really important things to think about at the front end. And you also want to think about, there have been times when, I've seen a workplace violence restraining order actually escalate a situation. And so, when we talk about down at the bottom of here, the effectiveness of the order, it's something that we want to think about as well. Do we think a person, is a legal threat like this going to be something that is going to make this person responsive, or is it actually going to raise a threat? So it's certainly one of those things that you want to discuss with multiple members of your team. And I saw a question about how fast you can get one. There's a lot of paperwork that goes with these. So you can put the paperwork together, you file it with Superior Court. Typically, Superior Court will make a decision on the papers that day or the next day. And then your TRO is good for 21 days. And then you have to go in and have an evidentiary hearing on a permanent. So if anybody's interested in talking about workplace violence restraining orders further, reach out to Megan and I. We're happy to walk those through, but there's a lot of interesting things to consider with that. And I'll turn it back over to Megan to jump into SB 553 further.
Thanks. So on the kind of background of all of the existing tools, then we had SB 553 come into being, work its way through the legislature, pass both houses of the legislature, and be signed by the governor. And Senate Bill 553 essentially does three things. First, it amends the California Civil Procedure Code section on workplace violence restraining orders. So there's a little bit of a change to how workplace violence restraining orders will work moving forward. And Rachel will talk about that one in a little bit. The second thing it does is it makes a change to essentially the injury and illness prevention program statute. Cal OSHA requirements live in stem from California Labor Code, and then often have even more specifics that live in Title 8 of the California Code of Regulations. And those are the specific regulations that we talk about, like 3203. And so SB 553 officially changes the IIPP requirement to make workplace violence prevention plan a requirement of IIPP. So essentially, you have to have a workplace violence. Your injury and illness prevention plan has to address workplace violence in a way that conforms with the specific requirements for the workplace violence prevention plan. And so that's a third thing that SB 553 does, is it adds a second labor code section that lays out all of the specific requirements for the workplace violence prevention plan, as well as some additional requirements such as training, record keeping, and maintaining a violent incident log. So before we get into, before Rachel goes into all of the detail of the particular requirements of 553, just a couple more kind of background things to keep in mind, which is mainly the deadlines and who is covered by this new rule. So the Senate Bill 553 takes effect January 1, 2024, so in the new year. But the requirement to maintain an effective workplace violence prevention plan kicks in July 1 of 2024. So employers have a few months before their plan has to be effective. But as Rachel will emphasize, there's quite a bit of work for employers to do And so it's definitely wise to be thinking about this now, thinking through developing your plan, implementing the plan, and what this is all going to look like. And then January 1, 2025, the expansion in the workplace violence restraining order requirement that allows, so I had mentioned that there's a little bit of a change there. One of the changes is that, and this one comes from SB 553, is that currently employers can obtain a workplace violence restraining order on behalf of their employees. Starting January 2025, collective bargaining representatives can also obtain workplace violence restraining orders on behalf of employees. And I think there was a question about which employers might be exempt from this workplace violence requirement for general industry. So this slide has the exemptions right there. As you can see, they're fairly limited. Obviously, those who are covered by the healthcare standard would not cover, and there's a few other very limited exceptions. So most employers are going to be required to comply with these new statutes. So just to kind of wrap up this section, the Senate Bill 553, as you can see earlier in this year, one of our senators introduced this, and this is really stemming from both a response to violent incidents in the workplace and a feeling that the regular rulemaking that was working its way through Cal OSHA was just not coming to fruition as quickly as the legislatures wanted. And so they went ahead and steamed ahead and pushed this forward. It went through quite a bit of amendments. It did start out looking a little bit more like the healthcare regulation, which is much more onerous, would be very, very difficult for smaller employers to comply with. And through great efforts, there were changes back and forth, and agreements reached on the version that ultimately passed both houses of the legislature and was signed by the governor, which looks a little bit more like what the Cal OSHA regulation was looking like, and not as much like the healthcare version. So that's what we have now, and I will pass it over to Rachel to kind of start getting into all of the details about what the specific requirements are.
Thanks, Megan. And I know we have a lot of questions coming in through the chat, so we will do our best to answer them as part of this presentation. But if we aren't able to answer your question during it, please feel free to either call or email any of us, and we're happy to walk you through any of those questions that we aren't able to hit today. As I mentioned before, this new bill, this new statute, it takes kind of a comprehensive team to look at. And one of the reasons for that is because the definition of what is workplace violence and what is a threat of violence encompasses things that in the employer world we're not used to regulating, we're not used to always being a part of. It's really kind of something that's outside of what we would consider, quote unquote, the work realm. And so, the definitions of workplace violence are really something that I want to make sure that employers understand and are paying attention to. And this is as you're putting together your plan, your training, and as you are, trying to make sure that this is operational. And one of the other themes of this presentation that I want to make sure folks get is that, like any occupational statute or regulation in the state, for the most part, this statute includes language that your workplace violence prevention plan has to be effective. And what that means is that it's not just enough to have procedures in place, it has to work and it has to be operational. So, when we're looking at things like what's the definition of workplace violence, you need to be thinking about how that's actually going to work in practice and start to think through what you as a company, what you as an employer are going to be doing in these circumstances. So, that's why, July 2024 seems very far off, but it's really going to take a lot of thinking through some of these scenarios and how you as a company are going to deal with them. That's work that should be starting now. So with that being said, workplace violence under the statute means any act of violence or threat of violence that occurs in a place of employment. That seems like a pretty narrow definition. However, it includes, but is not limited to, the threat or use of physical force against an employee that results in or has the high likelihood of resulting in injury, psychological trauma, or stress, regardless of whether or not the employee sustains an injury. So if the threat or use of force has the likelihood of causing psychological trauma or stress without an injury, it is considered workplace violence under this statute, and you have obligations as an employer to take actions. So I want to highlight that because that's not really an area as employers we're used to really delving into. So that is something for your consideration. It also includes incidents involving a threat or use of a firearm or other dangerous weapon, including use of common objects as weapons. Now, this is one, and I was involved when we went through the healthcare workplace violence rulemaking process many years ago. That standard went into effect in 2017, and that was one where we kind of had a lot of pushback on common objects. So that means if you have a pencil lying around, that's a common object that could potentially be used as a weapon, right? If you have a bottle, any of those things are going to be common objects that could be used as a weapon under this statute. And we'll move on to the next slide. It also includes a threat of violence, and that includes any verbal or written statement, including text, electronic messages, social media messages, online posts, or any behavioral or physical conduct that conveys or reasonably could be perceived to convey intent to cause or place someone in fear of physical harm that serves no legitimate purpose. Workplace violence does not include lawful acts of self-defense or defense of others. So again, this is going to include threats made over text messages, threats made over social media, pretty much any online posts that are now going to fall into the realm of workplace violence, and that things that an employer has to be regulating and made aware of. So what does that mean? This technically applies in a place of employment, but also these social media messages have to be taken into account too. So as you can see, it's a pretty broad definition that really falls outside of what typically employers would consider workplace violence. Physical violence that's happening in your brick and mortar workplace. This is far outside of that and encompasses a lot of different scenarios, and a lot of different scenarios that I don't think we've thought through or worked through, and that I expect we're not going to know the boundaries of until we start to litigate this, to be honest. And we'll move on to the next slide. And so the statute includes the different types of workplace violence, and these types aren't necessarily new types of violence. And a lot of the industry guidance and industry standards, you'll see violence broken out into these 4 types. So it's not something that is typically new. And why these 4 types are important is because it's going to affect how you fill out your violent incident log, which we'll get to later on. But we'll just walk through these types of violence quickly. The first one is it's committed by a person who has no legitimate business at the work site and who enters with the intent to commit a crime. So that's your third party, really criminal acts, things like that, that, you know, depending on your workplace isn't really something that, you know, employers had a lot of obligation over in the past. You know, these kind of random acts of third party criminal behavior. But this is included, and this is something that, you know, you're going to be logging and having to think about. The type 2 violence is that's directed at employees, customers, clients, and, you know, this is types of things that when you have a public facing employees that, you know, we see often. So it's not a totally controversial one in itself. Type 3 violence is basically employee against employee violence. Type 4 is one that employers, I think, are the most uncomfortable dealing with. And it's one where I've seen the highest rise lately in incidents. And it's types of violence committed in the workplace by someone who does not work there, but who has had a personal relationship with the employee. So, you know, the most likely we're talking about domestic violence or intimate partner violence that spills into the workplace or has the potential to spill into the workplace. And this is the, you know, one of those where you know, you really want to make sure that you're working with your attorneys, your employment attorneys, because there's a lot of privacy issues. There's a lot of interacting laws when you're dealing with things that have to do with, you know, the personal nature of a domestic violence issue or an intimate partner violence issue. So SB 553, it has a lot of different components to it. And the main one is to put together, an employer must have an effective, maintained, written workplace violence prevention program. And as Megan mentioned, now it's an element also of the IIPP to have a compliant program. Now you can have this program be part of your IIPP or a separate document. Our recommendation would be to maintain it as a separate document. It's going to be pretty big. I mean, it's not going to be that big, but I mean, it's going to be a good size document, and it, you know, reference it in your IIPP to where it can be found, and then, you know, have your separate plan, because it is going to also be a fluid document. It's going to be one that's going to probably have to have a lot of updating, and you don't want to keep those all separate. And one additional thing that I want to flag for employers, that not only does this have to be your plan have to be effective, but it also has to be specific to each work area and operation. So what does that mean? That means that you just can't have this generic plan that applies to your facility as a whole, that if you have multiple facilities, you're applying, you just have this generic template, and, you know, you just put the facility's name on it and you're good to go. It's really requiring that you are looking at each of your work areas, each of those operations, to ensure that you've evaluated the potential workplace violence hazards in those areas, and you've taken appropriate mitigation steps. So in healthcare, you know, one of the classic examples, and one where I always see employers getting hit on, is, you know, maybe they don't have something specific for the emergency room as opposed to, you know, outpatient, right? Like there are very different risks, and there's very different evaluation when you're talking about an emergency room versus an outpatient area. And this may be in a general industry employers. It might be areas where you have public facing, versus non-public facing, or, you know, parking lots, or, you know, folks that are working at, you know, areas that may only be open after hours, things like that, where the risks and the evaluation are different. And Cal OSHA is going to want to see that evaluation and identification as part of these plans. And I saw a question about who is enforcing this statute, and that's a great question. So, you know, Cal OSHA doesn't have authority to enforce the labor code. However, as part of this statute, the legislature included a provision directly providing Cal OSHA authority to enforce this standard. So they will be enforcing this standard, and they will continue. And the statute also directed them to continue to rulemaking on the regulation that they're already working on. So essentially what happens is that this statute becomes the floor of what's going to be required for employers, and then Cal OSHA can build on it from there. And we do not anticipate that Cal OSHA is going to have their new regulation out by July 2024, when this statute regarding the plan goes into effect. So what that means, unfortunately, practically speaking for employers, is that you're going to have to be prepared to be in compliance with this statute in July, but you're probably going to get more requirements coming down the road too. So that's the unfortunate reality of probably what we're looking at. And in addition, and we'll just go back to the, we'll go back to the slide. Just a couple other things. Oh, I did see a question about whether or not Cal OSHA is going to have a template available. We don't know. Cal OSHA has not said. Again, this statute is not their regulation. And so, you know, they may not put out a template, if they do at all, until they actually promulgate their own regulation. And one other thing to note is that for the healthcare regulation, which is a Cal OSHA regulation, they never put a template out. There is no template for healthcare workplace violence. So if they take the same approach that they did for healthcare, we may not see one at all. So it remains to be seen if what we may see from Cal OSHA, if at all. As part of your plan, you're going to be creating and maintaining records of workplace violence, hazard identification, evaluation, correction, and investigations. So that's all going to be part of the procedures for your plan, and you're going to also keep records of those. You're going to have a violent incident log, which we're going to talk about in a minute. Lots of additional record keeping requirements, and annual training that must be interactive. And so we're going to talk about that too as we move on to the next slide. So there are 12 elements of your written plan, and these are kind of the summaries of it. They are expanded in more detail in the statute. But, and I will say, kind of on the face, these don't look like that of onerous elements, but these are things that you're really going to have to dig into and as part of your plan. It's not just something you kind of slap together and you move on. You're going to have to really think about a lot of these elements. The first one, you know, not that onerous. You're gonna have to have the name and job titles of the person responsible for implementing the plan, or if there's multiple people, including them. Effective procedures to obtain active involvement from employees in the union, both in the process of putting the plan together, developing training, in all elements of the plan. And that's, you know, we see that become more and more included in the elements of Cal OSHA regulations. I think this is in the COVID regulation S2, but it's one that you're gonna have to think about and figure out how you're going to get active involvement, or at least have procedures for active involvement. Methods employer will use to coordinate implementation of the plan with other employers. If you have other employers on your site, if you are a multi-employer site, you have to be able to have procedures for communicating with those employers. If those employers have obligations, if you have obligations to those employers, there need to be procedures around that. Effective procedures to accept and respond to reports of workplace violence, and that means from employees or from whoever is making a report. So you have to be able to effectively get those reports, and how are you going to respond to those reports once you've done that? And that could be, you know, thinking through all the different types of reports that you may get and how you're going to respond to those. Procedures to ensure that supervisory and non-supervisory employees comply with the plan. That's going to be pretty similar to probably what you already have in your IIPP about how you get employees to comply with the IIPP. Procedures to communicate with employees regarding workplace violence matters. You know, that one seems pretty simple, but, you know, for example, an area where I see this come up a lot in healthcare is, let's say we've had an incident or a threat on one shift. Are we making sure that, you know, when the new shift of employees are coming in, that that's being communicated to other employees, things like that. So you really want to think through, just because maybe you've communicated an issue once, is it being communicated consistently through your workforce? And is it getting all of the employees, you know, is it hitting the right people? There are a lot of different things to keep in mind there to really make, again, this an effective procedure. Effective procedures to respond to actual and potential workplace violence emergencies. And a couple things to think about is workplace violence emergencies take a lot of different forms. There's not one form of a workplace violence emergency. You know, you're going to have your active shooters. You're going to have maybe, you know, intimate partner violence that, you know, comes to the workplace. And so how are you going to respond to all of those are things that you're going to want to think through and put in these plans, or at least have, you know, some type of outline for. Procedures to develop and provide training. That's pretty self-explanatory. Procedures to identify and evaluate workplace hazards. So how are you going to be evaluating these in your workplace? How are you going to be detecting them? You know, pretty similar to kind of what you do to determine any safety hazard in your workplace. You're going to have to do this specifically for workplace violence. And this is one where, you know, may evolve when you see different types of workplace violence come through your workplaces. You're going to have to evolve how you ID and evaluate. Procedures to correct workplace violence hazards identified and evaluated. This is probably pretty similar to what the procedures you're going to have in your IIPP and how you are correcting any safety hazard that you normally would. Procedures for post-response and investigations. Now that you've had an incident, your procedures for responding and your procedures for investigating and your procedures for maintaining those records. So, you know, that one is going to be one, again, that you're going to want to really kind of sit down with your team and think about who's going to be, you know, doing this. There's going to be potentially a lot of really private information depending on the type of incident that you are experiencing. And, you know, it may not always be a security person or an EH&S person. It may need to be an HR person. It may need to be legal, just depending on it. So you really want to think those through. Procedures to review the effectiveness of the plan and revise it as needed. And this is, again, one where I see in the healthcare setting that doesn't get done. And Cal OSHA loves to hit employers on it. So as I mentioned, so you have your plan, and you also have to maintain a violent incident log. So what that means is that the employer has to record information in a violent incident log for every workplace violence incident. So now if you remember, going back to our definition of what workplace violence is, that's a broad definition. There's a lot of things that could potentially be workplace violence. Now you have to investigate and log. And of course, that log includes a lot of information. So, date, time, location, classification of who committed the violence, classification of circumstances, classification of where the incident occurred, the type of violence, so going back to those 4 different types of violence, consequences, and information about the person completing the log. Now, one of the things that I think employers need to be thinking about as we, try to streamline your procedures is you're going to have your investigation report. So when you're putting that together, try to be gathering the information that's also going to go into your violent incident log, so you can kind of take that information and put it in there. Now, you're going to want to think through for your investigation report. Do you want to do an original one of those under privilege? What needs to be included? Are you going to have different types of investigation reports depending on the incident? And again, how all of those work together, things you're going to want to need to be thinking about now. Workplace violence training. So employers have to provide initial training when the plan goes into place, and then annually thereafter. So this will be annual training for all of your employees. And then you have to do additional training when a new or previously unrecognized hazard has been identified, or when there's changes to the plan. So that means, let's say you've had an incident in your parking lot because you didn't have enough lighting. Well, now you're retraining your folks to, make sure you're only walking in certain parts of the parking lot that are well lit, things like that. That's all going to be required here. Training also must include an opportunity for interactive questions and answers with a person most knowledgeable about the plan. So if you are not, like most employers or most large employers these days, you're doing maybe computer module training, you're doing on-demand training because you have shifts of workers and it's not always possible to sit everyone down and do a training at one time. You have to have them, they have to be able to have interactive questions. So what does that mean? If you're thinking about, California requires anti-harassment training under those regulations, the guidance there is that questions can be answered within 2 days. Is Cal OSHA going to find that acceptable? I don't think that they will, to be honest. If you're thinking about, this is a similar requirement to what we see, for instance, in bloodborne pathogen training, and they, require almost instantaneous answering of those questions. But this is also one where I suspect we're not going to see consistency from Cal OSHA. So you may see some district managers say a day is fine, or an hour is fine, or half a day is fine. We just don't know yet. And so this is one where, again, it's probably going to be litigated. If you want to be conservative, as close in time, but we really don't have a good answer for what interactive means at this point. So training, it must cover a whole litany of things, and I won't go through the full list because you guys will have the slides and in interest of time, but it does delineate in the statute the specific things that you have to train on. And then workplace violence record keeping. Now, this is a very easy one for Cal OSHA to hit you on. It's one that is really subject to repeat citations. I see this all the time in healthcare. So this is one that I really don't want you to overlook. Maintain your records of hazard identification, evaluation, and correction for 5 years. Maintain your violent incident logs for 5 years. Maintain your training records for 1 year. I would recommend, being closer to probably 2 or 3 years on that one, but it's 1 year under the statute. And then maintain your incident investigations for 5 years. Now, keep in mind that for the first 3 of these categories, you have to make those records available to employees and their representatives within 15 days, 15 calendar days. So just think about that when you're putting it together, the information you're putting in there. Of course, we want this to be accurate. We want it to be helpful. But remember, anything in those first 3 records, you have to turn over to employees or their representatives. So that's the main points of what's going to go into your workplace violence program, and kind of all of the different pieces there. And certainly that was a lot of information to cover, and there's a lot more details to get into. So please feel free to reach out to me or Megan or Andrea if you want to talk through those more. But those are just, you know, the highlights. You could do a full webinar on kind of, you know, on a lot of those different elements all in themselves. Just a quick note about workplace violence restraining orders, because as Megan mentioned, SB 553 does change those workplace violence restraining orders as well. So previously only employers could get a workplace violence restraining order. Now the collective bargaining representatives can also get that. Now, when I first saw this in SB 553, it didn't really bother me, because anybody who has gone through the process of getting a workplace violence restraining order knows it's a lot of work. It can be really expensive. It's a lot of time. And if a union wants to come in and take on doing that work, you know, I don't think that's a bad, you know, deal for the employer. And that is keeping in mind that at that time, a workplace violence restraining order was only limited to actual violence or credible threats of violence. So that's a pretty high standard. And for most of the time, there's not a whole lot of dispute previously about, you know, what would be violence, what would be a threat of violence. So when I saw that come in, didn't really bother me too much. But on the next slide, we'll see that at the end of the legislative session, we saw them slip in SB 428, which went into, which got incorporated by reference into SB 553. And what it does is it expands workplace violence restraining orders from just threats of violence and credible threats of violence to harassment. And which on one hand is good for employers, because if you have incidents where you have employees being harassed, you can now get a workplace violence restraining order. And this comes out mostly from a case that happened down in San Jose with a bank teller, where a customer was coming in and harassing this poor bank teller, and the employer went in and got a workplace violence restraining order. And long story short, it went up to the Court of Appeals, where the court found that it wasn't actually a credible threat of violence that was occurring, and overturned the restraining order. So, you know, it was trying to deal with that problem. However, we now have a situation where unions can go in and get these workplace violence restraining orders. So you may have a situation where, let's say, a union believes an employee is being harassed by a supervisor. Is that union going to go run and get a workplace violence restraining order against that supervisor? And as you can see, you know, that can potentially be a little bit more disruptive to your workplace. And there's, you know, a little bit more wiggle room as into what is considered harassment. So that's just one thing I want to flag. You know, we don't know, you know, how people are going to be reacting to those or going to be utilizing those. So one thing to keep in mind. And one thing else that 428 did was that it puts in there that you have to allow the protected employee, the employee you're getting the restraining order on behalf of, the ability to decline. So now, previously employers could do that and just get one, you are no longer able to do that. And just real quickly, you know, we talked about Cal OSHA is still in the rulemaking process. They're still required to propose to the Standards Board by 2025 a regulation, and the Standards Board must adopt it no later than 2026. And so we are not done on this subject. We are only beginning to see the requirements that are coming through. And we know that there is a draft. Cal OSHA has another draft available. It's waiting for approval, and they're allegedly going to have another advisory committee meeting for that. So stay tuned. And with that, we're going to hit the employer implications and different interactions of laws. But with that, I'm going to turn it over to my colleague, Andrea Chavez, who's going to walk us through this.
Thank you, Rachel. As Rachel mentioned, I'm going to go over how implementation of the Workplace Violence Prevention Plan will intersect with areas of law beyond just workplace safety law, including, employment law, workers' comp law, and common law. And just to emphasize something that Rachel said at the beginning of the webinar, if you develop and implement your plan in a vacuum, then you'll be much more likely to run into some issues with these laws, down the line. So we really suggest that HR, your safety specialist, and legal all coordinate to develop your plans. One major issue to take into account is that under the California Constitution and other labor laws, employees have a right to be free from unreasonable invasions of privacy. Now, these privacy concerns typically arise in the aftermath of a workplace violence incident, so during the investigation stage. And while it's very common and understandable for employers to adopt a rigorous approach to investigations, it's just important to remember that privacy laws remain applicable. And that's especially true when it comes to the collection and use of public and criminal records, surveillance of your employees, employee searches, which all have specific requirements of how that information can be collected, notice to the employees, and what that information can be used for. So essentially, employers need to balance their need to do an investigation with the right of employees to be free from unreasonable invasions of their privacy. And we have, these conversations with employers a lot, and we always ask, we always ask the employers consider whether their investigation is overbroad. Is the information being collected necessary? Are you following the laws to collect that information? Another thing to note is that during these investigations, you'll most likely be collecting and discovering sensitive and private information on the victim and the perpetrator. This is especially true because you may be dealing with, domestic abuse situations, mental health, injuries, which are all inherently private. And while SB 553 explicitly states that medical information is to be excluded from incident records, it should be noted that the definition of medical information is very limited to essentially records from a medical professional. And so employers should establish safeguards for protecting all this other sensitive information that's collected during investigations. Okay, so here's a list of some of the other intersections with laws that you should be aware of. One that I'd like to point out is the intersection with discrimination laws. The uniform application of workplace policies to all employees, regardless of protected characteristic, is always important. And the same goes for when you're implementing SB 553. And as also noted, the new law has a very expansive definition of workplace violence, including things like threats likely to cause stress to employees, which really gives a lot of room for interpretation to employers. So it's important for employers to set aside any preconceived notions about who might commit acts of violence and who isn't and isn't vulnerable to psychological stress when assessing these incidents and determining disciplinary action. So one example we have of where we see this in practice is when employers sometimes have an idea of, that men are most likely to commit acts of violence and much less likely to suffer stress from threats of violence. So employers should always ask themselves if they are treating alleged violence statements from a man differently from they would treat, those similar statements from a woman, whether they are assessing the likelihood of psychological trauma or stress differently, and whether the discipline is consistent for the gravity of the incident. And just to know, another area we often see this is with veterans, and the idea that veterans are more prone to violent acts, which isn't, shown or true. So again, just evaluating these incidents consistently is really crucial to avoid potential discrimination claims from the alleged perpetrators. Now, you guys don't really get a break because, on the other hand, workplace violence incidents motivated by a protected characteristic of the victim may result in discrimination and harassment claims from the victim. Okay, so moving on to the next slide. Okay, so under the common law of torts, employers have a special relationship with employees, giving a rise to a duty of reasonable care. Companies also have a duty of care to third parties that enter their premises. So that would be, clients and customers. For the employees, injuries resulting from workplace violence incidents will generally be covered by workers' comp. And that's typically regardless of fault. Now, there's an exception when employees' injuries result from the willful physical assault by the employer or an employer's ratification of such an assault by an employee. So in those cases, injured employees can pursue in civil court, and get damages for that against their employer. Okay, so moving on. Sorry, next one. Okay, and the last thing I want to point out is that employers should be wary of vicarious liability, meaning that they could be liable for the negligent acts of employees. And that would include civil lawsuits from clients and customers for claims such as negligent hiring, supervision, or retaining an unfit employee. So it's just important that whenever you have knowledge or should have knowledge of workplace violence, that you take action, because if you do nothing and that employee commits a similar act, you could be hit with one of these negligence claims. So yeah, so the last one is premises liability, which I mentioned previously. That's, that anyone who has control over the premises has a duty of care to those entering the premises. So, you want to make sure you have the right procedures in place to protect not only your employees, but again, the clients and the customers entering your premises. And then moving on, so this is kind of going back to the idea of what you can and cannot collect on employees, and we just wanted to give you some examples of these laws. I'm not going to go into it in depth here, but just to be aware, if you're, for example, if you're collecting information on criminal records, I'm sure most of you guys know that you can't collect information on arrests that did not lead to a conviction. Now there's a new law that's going to start next year about, there's very specific constraints around marijuana convictions. So these are all just things that you need to be aware of when conducting your investigations. And here's just another law that has to do with, the public records search. So, I mean, that's really what we wanted to go into with regards to the overlap into other areas of and other areas outside workplace safety law. So yeah, I think we can open it to questions now, unless Rachel or Megan have anything else to add.
Yeah, I mean, thanks, Andrea. I would just say, with the public record search, there's a lot of things to consider, and you want to make sure that you go through these laws before you start, checking somebody's social media, which is a typical thing to do. So for instance, you have a situation where employees are making threats of violence to each other over social media, and now you go and you review that. Do you have additional obligations under these certain laws in California? So, certainly something to think about, certainly things to talk to your attorney about as you're working through it. Again, these aren't something that works in a silo. Thank you for coming to our first Cal OSHA webinar. We have rolled out a whole Cal OSHA webinar series. So we have a Cal OSHA enforcement update and regulatory update December 5th. So, please sign up for that, and you can go to the website or email any of us if you want to be registered for any of these, all of these. We do encourage, even if you can't make the webinar series, if you sign up for them, you will get a copy of the slides and the recordings afterwards. So just go ahead and sign up for it. And so you'll get all the information anyways. And thank you to anybody who was able to join us in October for our in-person summits. We're going to be doing that again October 8th and 9th. So also keep that in mind as you are planning your year, and feel free to reach out to, I know there's a lot of questions in the chat. Feel free to reach out to any of us individually, call or email us, and we're happy to go through those as well. And I want to thank Andrea and Megan, who are wonderful colleagues on this, and for presenting here today. So thank you everyone for attending, and we look forward to seeing everyone on more webinars and talking to you all soon.